The point is that the situation has worsened, and that's worsened to a point that today many scholars, many experts are calling it a genocide, because the situation on the ground it's so grave that is putting at risk the very existence of the group, of the Palestinian group of Gaza as such. And I really believe that this long-lasting impunity, which is decades long, not 2 years, not even 10 years, it's much longer than this, because the documentation about not only the unlawful behavior but also the commission of very grave crimes by Israel is many, many decades long. The states, and in particular I'm talking about European states who can exert a leverage on Israel, but of course the United States are complicit for their unconditional support to Israel that continues to till this day, have played, unfortunately, a very negative role in fostering this violence through conceding a total impunity. And this has undermined not only the situation in Palestine, but it is risking of completely destroying any confidence in the international legal order and the rule of law at the world level. My inspiration to keep on going are people like Raji Sourani and the other Palestinian human rights lawyers and defenders, which with their not only their work, with their entire life, if they say we don't have a right to give up, who I am to say we should give up? So I think we still have to fight for justice and to keep our principles very clear and not give up. It will be the last thing I think we should do.
As of September 2025, over 64,000 Palestinians have been killed in Gaza, with 83% of the casualties being civilians. This includes over 20,000 children. The International Association of Genocide Scholars, representing over 500 experts, has declared that Israel's actions meet the legal criteria for genocide under the 1948 UN Convention. Hello and welcome to another episode of Gaza Stories. I am Munif Khan, and joining us today is Chantal Meloni, an international criminal law professor at the University of Milan, Italy, and senior legal advisor at the European Center for Constitutional and Human Rights, Berlin. She also consults with the Palestinian Center for Human Rights and represents victims in Palestine before the International Criminal Court. Today, we discuss the legal implications of the genocide in Gaza and the urgent need for accountability. Professor Meloni, thank you for joining us.
Thank you for having me.
Yeah, I'm sure that before we start this interview, I'm sure just for the audience to know that we have received reports of an airstrike in Doha by the Israeli forces. And which brings me to my first question, and which also goes to this idea of jurisdiction. So while Israel is the occupying force in the Palestinian territories, and in many cases it exercises military control, but what I want to ask is, what are the specific legal obligations does this impose on Israel under the Fourth Geneva Convention, and how are these obligations being systematically violated today?
Yes, indeed, what you said is correct. Israel is the occupying power in the Palestinian territory, and this has been confirmed without doubt also recently in July of last year by the International Court of Justice, which declared the entire occupation of the Palestinian territory by Israel, which is ongoing since 1967, unlawful. Nevertheless, until the occupation continues, Israel is under specific obligations that are those that are deriving by international humanitarian law, and in particular, yes, the Fourth Geneva Convention. In particular, as the occupying power, Israel should be in a position to not only not damage, not harm, not put at risk the life of the civilian population of Palestine and in particular of Gaza, but to actually protect them, to make sure that the people that are civilians, that are not implicated directly in the hostilities, have safety, and that the humanitarian access is guaranteed to them. On the contrary, what we have been assisting to in the past 23 months is the absolute denial of each and every of these obligations. Israel has tightened his closure on Gaza, which it's good to remember was already in place before the 7th of October 2023. And it would be, of course, very naive to think that the conflict started 2 years ago. So the point is that the situation has worsened, and that's worsened to a point that today many scholars, many experts are calling it a genocide, because the situation on the ground it's so grave that is putting at risk the very existence of the group, of the Palestinian group of Gaza as such.
And coming to the situation on ground, and this brings me to the latest report by the Palestinian Center for Human Rights. It was titled Voices of the Genocide. Now, it provides documented evidence of mass killing, forced displacement, destruction of civilian infrastructure, and attacks on medical facilities. Now, what are the key criteria outlined under the 1948 Genocide Convention to address these violations? And I've read this report, and we've also read that it has gone as far as targeting IVF facilities, which is basically the act of preventing birth. If I'm not wrong, Article 2D under the so-called convention. So again, my question was, what are the key criteria outlined in this regard?
The legal definition of genocide is contained in the Genocide Convention that was already adopted in 1948. And since then, this definition has become customary law. It has been included also in all other international instruments, including most recently in the Rome Statute, so the Statute of the International Criminal Court. So the definition of genocide is still the same since the beginning of its first inception, when it was adopted exactly in 48. And it is basically a list, a catalog of conducts. In particular, there are 5 conducts that integrate genocide as a crime. And these are not only the killings. So, of course, the first one is killing the members of a group, but also other type of conducts which sometimes are forgotten, because beside the killings, of course, also wounding and torturing and inflicting serious harm to the body of the individuals of the group is one of the conducts, and inflicting measures that make the life of the group impossible, the existence in a certain territory. So inflicting conditions, this is the wording that the Genocide Convention use, incompatible with the existence of the group as such. Also, there are conducts that relate to preventing birth or targeting the possibility to reproduce, so to have children, and to, of course, have safe places to grow up these babies, these children for the group. And finally, there are also conducts that have to do with transferring children from one group to another. And these conducts have to be, of course, in parallel, have to be met with something from a mental element, from the subjective level, that is the intention to destroy the group in total or in part as such. And as group, what is meant by the Genocide Convention is a group that is defined according to racial, national, religious, or social criteria. And of course, the Palestinians are recognized as a group as such according to different criteria. So there can not be any doubt about the fact that at least some of the conducts, as we have listed them, that are considered to be acts of genocide under the Genocide Conventions are met. And I think the report that you were mentioning, the one presented by the Palestinian Center for Human Rights of Gaza a few days ago, and that was, by the way, also submitted in the hands of the ICC prosecutors at the end of last week, it's a very important document that it's only the last confirmation, but very important because it brings on the front the testimonies, the witnesses directly firsthand from Gaza. But it's only the last document that is confirming this conclusion that is now, I would say, shared by the majority of legal scholars, in particular international law experts, genocide scholars, and even in the Jewish community of Holocaust survivors. Some of the maximum experts at the world level are today left with no doubt that we can call a genocide what Israel is doing in Gaza, and that all the protections that are there at the international level should be activated, because not only there is a risk, but there is a genocide that is ongoing against the Palestinian people. And this, of course, is a finding that triggers obligations also with regard to third states. This is very important to remember. Maybe we can talk about it better, but the point I want to make is that it's not needed to wait for a final judgment by the International Court of Justice, which will come probably in a few years, because unfortunately the timing of international justice are very slow. But we have to be very clear, the convention is called the Convention on the Prevention and Punishment of the Crime of Genocide. So the main purpose of it, as it was drafted in 1948, was exactly this, to act before a genocide is fully committed and completed, when there are the signs of a genocide, a risk of a genocide, and in this case it has been already considered to be plausible, then this is enough to trigger very clear third states obligations.
And I want to come down to the systemic impunity. I mean, you yourself have criticized the persistent impunity surrounding Israeli actions in Gaza. In your assessment, why have decades of documented violations failed to result in meaningful investigations or prosecutions at, let's say, the ICC and other international bodies? Because even from my perspective as a layperson, there seems to be more than sufficient evidence.
I think this is one of the most crucial points, and this is from my perspective as an international law scholar, and not being directly involved in, of course, not being Palestinian or not being Israeli. I consider myself someone who's observing from the outside, and I consider my countries, in particular European countries where I am based, Italy, Germany, but we can extend this course also to any other UN country that is currently observing what's going on in Gaza without taking concrete measures, as responsible for not having, as I said, taken the necessary steps when it was still possible to take them, to try everything possible to stop the unlawful behavior by the occupying power. And I really believe that this long-lasting impunity, which is decades long, not 2 years, not even 10 years, it's much longer than this, because the documentation about not only the unlawful behavior, but also the commission of very grave crimes by Israel is many, many decades long. has created a climate of impunity that has fostered violence. And in 2009, there was a very important UN fact-finding mission that was concluded after the operation that Israel called Casled. Maybe you remember that it was the end of 2008, beginning of 2009. It had triggered already a very strong international reaction because it was blatant, the commission of grave war crimes and also crimes against humanity. At the time, the Goldstone report, so it was under the name of the president of that fact-finding mission, had already concluded that there was evidence that was sufficient to claim that not only the Palestinian armed groups who had launched rockets that also could integrate war crimes because they are indiscriminate, of course, and they also targeted civilians, but in particular, the Israeli forces had committed very, very grave war crimes against the civilian population, and even the crime, possibly the crime of persecution as a crime against humanity. And this was already because of the collective punishment of the civilian population of Gaza. Just to remember the facts, the blockade on Gaza, the tightening of these blockade that had been already imposed by Israel in the past became almost complete, total in 2007 after Hamas took over. So at that time it was 3 years since the beginning of this tightening of the blockade. Now we are talking about how many years? Since 2007 we are talking about 18 years of a situation where the civilian population, over 2 million people, is collectively punished, and now it's exterminated, and of course with absolutely no possibility to find any safe place. So the fact that the international mechanisms, and in particular international justice mechanisms, but also sanctions that could have been taken, and even if we don't want to talk about sanctions, it could have been already something to give a political message to Israel to start reviewing, for instance, the European Union association agreement with Israel, which is rewarding Israel, of course, with economic benefits when it became clear that human rights were violated, given that this association agreement is based on the assumption that human rights are respected. So what I mean is that the states, and in particular I'm talking about European states who can exert a leverage on Israel, but of course the United States are complicit for their unconditional support to Israel that continues to till this day, have played, unfortunately, a very negative role in fostering this violence through conceding a total impunity. And this has undermined not only the situation in Palestine, but it is risking of completely destroying any confidence in the international legal order and the rule of law at the world level.
And now I want to come to testimonies, because you also mentioned testimonies when we were discussing the question on the report from the PCHR. And in cases related to violations under international, so in the cases related to violations of international laws within Gaza, there are countless heart-wrenching testimonies you must have received and you must process. We've read this in the report ourselves. How do prosecutors decide which testimonies to admit to record when it comes to the legal process? Because I'm sure there is a procedure over there as well. And could you simplify this for our viewers?
The selection of which cases to bring forward in an investigation, big as broad as the one that are brought in front of the International Criminal Court, is one of the most difficult aspects of this work, because there is, of course, a tension between bringing to justice an entire structure, a situation that, as we said, it's not 2 years old, it's many decades old, and it involves a systemic structures and decisions that come from many years ago, including the decisions that were made right after 1967, after the starting of the military occupation of the Palestinian territory and the decision to colonize them, establishing what we call colonies, and everything that then developed into what today can be described as a form of apartheid for the Palestinian people. So we are talking about a system of systematic oppression and institutionalized regime that discriminates against millions of people that are living on the territory of what was originally the historical Palestine, and they are not citizens of course, the occupying power. They are considered basically without rights, and at the same time, an investigation, especially a criminal one, in front of the ICC, has to focus on individual criminal responsibilities, so specific acts, specific conducts of specific persons, individuals. So there is a big effort to be done to individualize these systematic crimes and big decisions. And we have seen so far the issuance of 2 warrants of arrest. Of course, last year's November, it was publicly announced the issuance of the warrant of arrest against Benjamin Netanyahu, the Prime Minister, and the former Defense Minister Gallant. And we haven't had access to the warrants themselves, but only to press release around it. What we know is that there are some very grave crimes included in these warrants, including intentional targeting civilians, including starvation as a weapon of war, including persecution as a crime against humanity. But we don't have the details about what exactly, where, and when. We can assume that for crimes like starvation and persecution, these are big, broad conducts that are ongoing, by the way. So we are talking basically about potentially the entire population of the Gaza Strip being victims. And when we talk about attacks against civilians, normally what the ICC does is to try to concretely identify some incidents and to try to of course, put together a strong case, which means to have access to evidence regarding specific incident. One of the first that comes to my mind that I can imagine could be included in very concretely ICC investigation and then trigger cases in front of a trial chamber are the cases of, for instance, the targeting and killing of journalists, which are in some cases very clear-cut cases, or the case of the targeting and killing of the paramedics and medics of the Palestinian Red Crescent on the 23rd of March of this year, that have been, as you remember, killed when they were on their way to rescue some of their colleagues in the southern part of the Gaza Strip, and they have been executed by the IDF and even buried. Even the ambulances crushed and buried under the sand in one of the gravest crimes that you can commit in a war. So what I can say is only that normally the Office of the Prosecutor tries to build some cases that are, of course, manageable. It's not possible to have too broad cases, and always we have to remember which are the limitations in terms of jurisdiction, which is limited by time, so the temporal jurisdiction cannot go back before June 2014 in terms of territory and in terms of who can be the perpetrators. In this case, as you have seen, they decided to go all the way up till the Prime Minister, which I think it was the right thing to do.
And I'm going to ask this from a strictly legal standpoint, and this has more to do with international responsibility. How does the principle of universal jurisdiction apply to the documented crimes in Gaza, and what powers can neutral states exercise under international law to pursue accountability for acts of genocide or war crimes?
This is another very important component of how the system of international criminal justice works today. The International Criminal Court that we were talking about is, of course, at the center of this system. It is an independent institution. It has been established through a treaty. It has 125 state parties that join it. Unfortunately, not India is not a state party, not China, not Israel, not the US. So very important and very large population of the world is not included in the ICC system. But the ICC can only work if it is properly supported, also in terms of sharing the burden of investigations by national authorities. And this is a big role, is a big task that national prosecutors and national judges can and must take, using the principle that you mentioned, universal jurisdiction, which is based on the idea that some crimes that are the international crimes, so genocide, crimes against humanity, war crimes, and aggression, are so grave that they basically are of concern of the entire international community, as a whole, regardless of where they are committed, by whom they offend the entire international community. And on this basis, which was already recognized many years ago, many national jurisdictions give the power to their judicial authorities to open, to investigate, and to also to have criminal investigations and proceedings against foreigners for crimes committed abroad. So universal jurisdiction means that an investigation is started regardless of any other jurisdictional link. The crime is not committed on the territory of the state, not by a national of a state, not even against a national of a state, but the state, for instance, Germany, uses a lot universal jurisdiction, and it has very successful also history of recent history of activating universal jurisdiction cases with regard to the crimes committed in Syria, for instance, by the Syrian regime Assad against their own citizens. Exactly on this principle that I was telling you, that it is something that is of concern of the entire community. And in the case of Syria, Germany did well also because Syria was left outside of the ICC jurisdiction. So there was also this idea, we have to find an alternative. With regard to Israel-Palestine, we have seen for too many years, and honestly, we are still seeing a reluctance by national prosecutors to open investigations against Israeli soldiers or politicians. And even if some attempts were almost successful in the past, I just want to recall the warrant of arrest that had been issued against Tzipi Livni in London almost 15 years ago, but then she was given a special immunity and she was never arrested, and she left the country in time. Actually, her plane landed and left without touching the UK soil because she was tipped off of this warrant waiting for her. But what I mean is that we have seen political interferences in the exercise of justice, and it's not a secret that some investigations against some country leaders or members of the military are more difficult than others, and this is the case with regard to Israel.
And that actually is the perfect segue into my next question. And this was something based on, stuff that you have highlighted in the past. You've highlighted how the international legal system often sidelines the voices of Palestinian victims and activists. And this is also based on your writings. And I wanted to ask, based on your experience, what structural changes are necessary for our international institutions to ensure that these voices are heard and legally recognized in proceedings?
Yes, this is one of the most ugly, I would say, aspects of this, like how Palestinian voices, Palestinian victims have been sidelined and were not taken into enough serious consideration, so that at the international level there is like a feeling that although Palestinians started to talk about apartheid since 25 years ago already, until big organizations like Amnesty International or Human Rights Watch didn't publish a report saying this is apartheid. No one dared really, using the word. It was even perceived as something that could be controversial or an insult, and it was forbidden basically in the mainstream media even to talk about this. And the same we have seen it happened with regard to the word genocide in these last 2 years, when for the Palestinians themselves, it was very clear from the beginning, because of the level of the declarations, the statements that were given by Israeli officials, of course, also coupled with concrete actions, that something new was happening. And this time it was not just another destructive military operation, but it was going to be something much, much worse, which in fact is. This was clear already in the first weeks after October 7, 23, but they were silenced, and until international law experts or even better Jewish voices raised to say, yes, we also think this might be or is a genocide, then this basically remained almost forbidden word. So there is an issue about not giving voices to the victims, those who know, those who document on the ground. And in my opinion, this is a consequence of a structural racism that we all experience. And unfortunately, especially in countries like, yes, European countries, Western countries, there is sometimes even a subconscious, sometimes it's very conscious, but sometimes it's even a subconscious form of undermining the voices of those that we don't consider to be authoritative.
And, you mentioned voices, and we've been seeing reports of hundreds of people in the UK being arrested under terrorism charges for peaceful protests. And let me make it clear, for supporting Palestine Action, which has been designated as a terrorist organization. Now, going by this, what does this precedent entail for constitutionality and fundamental rights around Europe? Because after all, these are still peaceful protests.
Yeah, the repression of the voices of those who speak in favor or for Palestine, it's a huge problem, and it's going to be one of the biggest battles, and it is already. I also think there is a framing of the entire picture, because it's not about being pro-Palestine, against Israel. It's really about being pro-human rights, pro-rule of law, pro-international justice, against impunity, against genocide, against international crimes, against the brutal use of force. So I think we should push back more against this framing that is in the media often used, pro-Pal or against Israel, things like this. I personally refuse it. I always said, and I often say when I speak in public, I'm not here to speak as a pro-Palestinian lawyer, which I'm not, by the way. And I'm here to speak from the point of view of what are human rights and what does international legal standards say. So the attack against these groups should be more successfully framed as an attack against, again, the rule of law and the demand of justice, which are universal. And that's why it's absolutely unacceptable what is going on, for instance, in the UK, as you mentioned, but also in Germany, in Italy, in many other European countries where every form of solidarity and support to the Palestinian cause is labeled as something that is dangerous, sometimes even associated to terrorism or to very infamous charges.
And this brings me to my final question, and this is more to do with defining justice in the current context. Based on your scholarly work and field research, is justice even possible for Palestinians in a world where Israel enjoys this impunity while committing genocide?
This is not an easy question. I would like to have an answer. I, of course, still believe in justice, otherwise I wouldn't do this work. And my inspiration to keep on going are people like Raji Sourani and the other Palestinian human rights lawyers and defenders, which with their not only their work, with their entire life, are really teaching all of us the way forward. And I think until they believe in it, they fight for the rule of law and justice. If they say we don't have a right to give up, who I am to say we should give up? So I think we still have to fight for justice and to keep our principles very clear and not give up, because this is exactly what they want us to do. And it will be the last thing I think we should do.
And I really appreciate you taking the time to join us, ma'am. And I hope you continue to do what you do. Thank you so much for this.
Thank you.